This guy could have been gone 5 years and his mail still would have been sitting there because he's out to court.
So, Your Honor, just to your point with respect to other cases, my understanding of those cases is that they relate more to when an inmate has been permanently transferred, i.e. they're released on parole or they're transferred to a different institution. I would concede that under those circumstances that the law is sufficiently clear that would require the mail to be forwarded. But this is...
Well, why is that different in the sense that if he was paroled or something, he could say, I don't know where he went. Or if he was transferred, he could say, well, my computer system didn't have that transfer put into it, or he might have been transferred to another jurisdiction permanently. Sometimes you finish your California sentence and then you have a detainer from Oregon. And they say, well, he's gone. We'll just wait. He's not going to ever come back. So we still got his mail. What's the difference?
Well, in those cases, there hasn't been the issue of whether that they lacked a forwarding address for them. Certainly if they're paroled, there's going to be an address. Here,
I don't know. I mean, if they turn him over to Oregon, just the same as turning him over to a U.S. Marshal, how would you know that there's a forwarding address? I mean, in those cases, was it very clear that they had a forwarding address?
I believe so, Your Honor. My recollection of
okay, we can look.
I'm sorry?
No, I'm just saying, you may be right. We can look at that.
Do you want to reserve any time for rebuttal?
Yes, Your Honor, I would. I did just see my clock.
Okay, we'll reserve your remaining time.
Thank you.
Ms. McConaughey?
Morning, Your Honors. May it please the court, Pierce McConaughey for Plaintiff FLE, Anthony Penton. In short, Your Honors, there are two independent reasons why this interlocutory appeal should be dismissed. First, because Defendant Johnson has failed to take the facts in the light most favorable to Mr. Penton, this court lacks jurisdiction to hear this interlocutory appeal. And second, if the court does decide that it has jurisdiction, the law is clearly established to put Defendant Johnson on notice that what he was doing violated Mr. Penton's First and 14th Amendment rights. As this court noted in 2020 in Boggs, and Lee v. Molina, if the appellant fails to take the facts in the light most favorable to the appellee, this court lacks interlocutory jurisdiction.
Couldn't we look at this record in the light most favorable to the plaintiff and then proceed to deal with the merits?
In this situation, yes, Your Honor, you could.
Because it seems to me we've got a legal question with regard to clearly established law or not.
Yes, you're right. Your Honor, there is, I think what's important to recognize, however, is that Defendant Johnson has always maintained that he didn't have a forwarding address for Mr. Penton. This is a fundamental disputed fact that needs to go in front of the jury. The only position that Defendant Johnson has ever provided for that is his own self-serving statement at his deposition. In contrast, Mr. Penton has provided plaintiff's expert Daniel Vasquez to ER 0245. Mr. Vasquez, being a warden for a number of years at San Quentin, who said yes when asked, does the computer system say where an inmate is when they've been transferred out to court? Yes, it does. As a result... But you didn't take any deposition or anybody in the prison system. That is, there was this litigation coordinator person. I didn't see a deposition or a statement from that person. Presumably the person who has the computer system. Are you saying it's a disputed fact that the address was there all the time and Johnson just didn't look? Yes, Your Honor. I think it is a disputed fact because it's a question for the jury to decide whether or not Johnson is credible. He needs to it's his prerogative, to testify on the stand, but the jury's going to decide, is this credible or not? And I would, even if this court were to say, you know what, computer system only says that Mr. Penton's out to court. Yeah. As you noted, I hope it says he's in the custody of the U.S. Marshals. And in fact, Your Honor, it's an undisputed fact that he was in the custody of the U.S. Marshals. Under 1 ER 16, the court says he's in the custody of the U.S. Marshals. The U.S. Marshals came and picked him up on November 8th, 2007. They returned him on June 19th, 2008. And I would like to draw your Honor's attention to Title 15, Section 3147, which Defendant Johnson said was part of his job duties to follow. And that says that mail shall, quote, be immediately forwarded to the facility or agency that has custody of the inmate. U.S. Marshals, undisputed, had custody of the inmate. Why not forward to the U.S. Marshals? Separately, as Judge Boggs, as you noted, there's no indication that anyone did anything with this mail other than stick it in Johnson's terms, a, quote, pigeonhole, also known as a cubby, in the back of the mailroom. And this is really solidified by... Sorry, I'm so sorry.
Excuse me for interrupting. If you wouldn't mind a question.
Of course.
I thought the record showed that there was a box they put the mail in for those who were not deliverable at the prison. You've referred to it as a cubby hole, and there's some other descriptions in the briefing. What in fact was it, and where was it, according to the record? Not according to your understanding or what your client has said, but in the record, do we have a description of what it was and where it was and what was done with this, whatever this facility is that they put mail where the prisoner is no longer in their facility?
Absolutely, Your Honor. So there is a record. It's Johnson's own words himself. And I think some of the confusion about what's going on is in part because Johnson, in his deposition, sometimes refers to it as a cubby, sometimes refers to it as a pigeonhole, sometimes refers to it as a box. To be clear, the mailroom, as described by Defendant Johnson in his deposition, is one large room with several desks, a few computers. There is no extra walls. It's a bit smaller, I suspect, than this courtroom, but just as open. My understanding is that, according to Defendant Johnson, this was stuck in either pigeonhole, cubby, box in the corner. Your Honors, I think it's also important to recognize that it's not clear that anyone ever actually looked at this supposed computer system. And that's particularly evident by the fact that while Mr. Penton returned to California State Prison on June 19th, 2008, he didn't receive his mail for 40 days. He didn't receive his mail until July 29th, 2008, 4 days after his father died. We'd submit, Your Honor, that these questions, when you take them in, as Mr. Penton has put them, as the computer system did have his address, as in fact it was Johnson's practice that caused this delay, as it was the fact that, okay, perhaps you should have sent it to the U.S. Marshals. Johnson never did this in his opening brief, and thus this court lacks jurisdiction to hear this appeal.
Well, when you say, as Judge Forrest did, that we could ourselves look at the facts in the light most favorable, and what is your statement of the facts in the light most favorable? Tell us, Johnson did X, Y, or Z. How do you read what is in the record that would be the facts most favorable to you?
Absolutely, Your Honor. So what's in the record is that Johnson, through his training of his subordinates or by his own actions, caused Mr. Penton's mail to accumulate somewhere, Your Honor, in the mailroom, in the office that he was in. As a result of this, under precedent, under Simpkins v. Bruce, 10th Circuit, 2005, which has nearly identical facts to this case.
Well, you're moving into law, trying to stay on the facts.
Yes.
Would you say something like, as a result of Johnson's actions, the mail was not forwarded?
Yes, Your Honor.
With the key being as a result of Johnson's actions, which would then let you go to proof of recklessness, negligence, willfulness, stupidity, whatever.
And I think the Ninth Circuit model instructions on supervisor liability are in 1983, supervisor liability are particularly illustrative of this point, that yes, Your Honor, it's actions or inactions.
And so going back to the facts, I think another fact that I understand your briefing to assert, and I think you would need to assert, is not only did his practices result in this delay, but it was knowable or it was discoverable where this mail should go.
Yes, Your Honor. And that is a question for the jury.
Although the exact method of discoverability in the sense that who signed him out or how you would find out it was signed out, that's an open question. I mean, granted, this all happened 16 years ago and we know computers have developed, but I put Mr. Penton's name into my browser bar and I got a thing which said Warren County Jail, 920 Kentucky Street, Bowling Green, Kentucky.
Right. Yes, Your Honor. And that's exactly our point. And we would submit, in addition, Your Honor, that when you do take the facts in the light most favorable to Mr. Penton, with,